Good morning or afternoon, or maybe evening to all of you. Thank you for joining the first webinar for SPSP this year. SPSP is proud to continue our putting on of these webinars. This year we might have up to 10 webinars to put on. There are lots of things to talk about, and we appreciate all of you participating and registering. And the numbers of people who have been signing up for the webinars indicate that you feel it must be useful. So we hopefully will keep up that tradition. As in prior years, we want to thank Sedgwick Brand Protection for sponsoring this year's webinar series. They are recall management specialists. You're all familiar with them, and we appreciate their support of these webinars. So there's a lot going on in CPSC land, and those of you who were able to attend, we had a webinar in October with the leadership of the CPSC, and having the new leaders of the CPSC participate in that program. And I thought they were pretty forthright about things they were doing, things they were thinking, and they agreed to answer questions. So if you haven't seen that webinar, it is on our archive page, and you can watch that also. Hopefully, we know more than we did back in October about what the CPSC is doing or is talking about doing. And our speakers today will kind of ruminate about where things are going or might be going, with the proviso that we're predicting the future. And that's a little bit tough given a government agency that is getting pretty aggressive out there. So let me introduce our two speakers, and then we'll get into the first topic. Matt Cohen is counsel at Crowell & Mooring in Washington, D.C. He practices in the mass tort, product and consumer litigation, and product risk management groups. He's been doing this for 14 years and has specialized in all aspects of laws pertaining to the Consumer Product Safety Commission. Our second speaker, Jennifer Keenan. Jennifer has been practicing in both product safety and product liability litigation for over 20 years, first at several large firms, and then in 2018, she struck out on her own and is the principal in Jennifer Keenan Law, LLC. And she is involved with both CPSC, Health Canada, NHTSA, and all agencies that deal with safety. So with that being said, let me just, you don't need to see that. You already heard who we are, and our faces are on the screen. So here's the agenda. So we'll talk about the organizational changes and see what we think that they mean. CPSC came out with operating and strategic plans, and there's some interesting gems buried in those things. I'm going to post the operating and strategic plans on the SPSP website with the slide. Well, the slides aren't that useful, but with the recording, a link to the YouTube recording of this webinar. So you'll be able to see some things that we will post there that could be useful and fill in some of the gaps. But anyway, these operating strategic plans have a lot of interesting things there. We won't have time to talk about all of them, of course. Next, the big topic that's been in the news, corrective actions, enforcement in the whole compliance area. We'll talk about those, rulemaking and legislation, and then laws, and we'll take questions at the end. So I'm going to stop sharing because that's what we're going to be talking about. You can see us a little bit better. And so with that said, I am going to start with Matt to talk about the evolving commission and both the commissioners and the staff, and see what he thinks is going on here and what's going to happen. Matt?
Thanks, Ken. Appreciate it. First, thanks for the invite. Thanks to SPSP for hosting this webinar. I took a quick look at the participant list, see a lot of friends, and hope to see people in person down in Florida at ICFSO next month. Jennifer and I have done panels previously, and it's always a pleasure to be with her. So I like to call this piece the Evolving Commission. There's been a lot of recent structural changes at the commission, starting with the makeup of the commission itself. Take you back quickly to the beginning of 2022. Last year, we had a commission of 4, 2 Democrats, Chairman Alexandra Hohn-Sarek and Richard Trumka, both confirmed in October of 2021, and 2 Republicans, Dana Biacco and Peter Feldman, who have been on the commission since 2018. There was a 2-2 party split at the beginning of last year, which came with some political stalemate. For those of you who are CPSC nerds will remember there was a little fight last year about last year's operating plan. For a very brief window in time, there was actually a 2-1 Republican majority, and Commissioner Feldman and then Commissioner Biacco were able to pass a few amendments, and that caused a bit of a stir. And then when Richard Trumka was confirmed, it brought the commission to that 2-2 split, but the Democrats weren't able to sort of undo what the Republicans had done. So anyways, there was a bit of that political stalemate. Then in June of last year, after a lengthy nomination process, the Senate confirmed the CPSC's then executive director, Mary Boyle. I'm sure a number of you have worked with her over the years, to the commission, and this was significant for 2 reasons. First, it brought the commission to 5 commissioners, so had a full complement of commissioners for the first time since 2019, and it gave the Democrats a voting majority since May of 2018, so about 4 years. Currently, the Democrats maintain that voting majority 3-1, with Commissioner Peter Feldman being in the minority. However, the full complement of having 5 commissioners was short-lived because, as many of you know, I want to say in October, then Commissioner Dana Biacco returned to private practice, bringing the number of commissioners back down to 4. Let me just speak for 1 more minute about staff changes at the CPSC, and I want to focus particularly on the compliance function, and I know we're going to be talking a lot about the compliance function today. A few years ago, when Rob Kay joined the commission as the Director for Compliance and Enforcement, he advocated for a bit of a change in the CPSC's compliance model, the staffing model, whereby some years ago, compliance officers ran most files. You file a 15B report, you were assigned a compliance officer. Well, over the past year or 2, as I'm sure many have noticed, we're now dealing with compliance attorneys. The compliance officer function has been phased out. For those who maybe have retired early, those positions are being backfilled by attorneys. And there's been a real expansion of compliance attorneys. And I would argue that the compliance function now at the CPSC resembles the FTC and some other agencies where you're dealing with attorneys as opposed to non-attorney compliance officers. And I think that has been very significant in the way that the compliance department has functioned over the past year or 2, along with a more aggressive overall commission, both at the commissioner level and staff level, given that we now have a majority of Democratic commissioners. I think that sort of comes with the territory and the stereotypical traditional political bent of the commissioners and the parties. So with that, I will send it back over to Jennifer, who I believe is going to speak a bit about this year's operating plan.
Well, now, before Jennifer starts, let me just say one thing on that.
Sure.
I have invited Rob Kay and his compliance staff, or leaders in his compliance staff, to participate in an SPSP webinar. I haven't heard yet back whether they'll do it this year, but I do have an invitation out there. And in the October webinar, they did talk about compliance a little bit, and the general counsel was there, talked a little bit about that, but there's some maybe in the weeds questions that we might get to today, but there's some things that they could talk about that would be useful, and have a platform for communicating a message to a lot of people at once. So I think they always like that, which is why, of course, they always speak at ICPSO, another opportunity to get the message out. So hopefully we'll do it. I've invited him several times. We'll see if he does it. One other thing, and I should be careful here, there may be some new people on these webinars, so I probably should introduce myself. I didn't bother to do that. My name is Ken Ross. I am the organizer and moderator for the webinars. I'm on SPSP's board. I was on ICPSO's board for 6 years. I've been doing product safety for about 45 years. And so I hopefully can add something to the discussion, but leave it mostly to the speakers to take over. So with that, let me turn it over to Jennifer to talk about the operating plan.
Hi, good morning or good afternoon, everyone, depending on where you are. Thank you to SPSP and Ken for inviting me to speak here. And as Matt said, we have spoken on seminars before, so it's always good to speak at a seminar with him. I'm going to talk a little bit about the 2023 operating plan. It's a 66-page document, so I'm only going to highlight some of the key provisions in the short time that we have here. The operating plan is based on a requested budget increase of $56 million, which would bring the budget for the commission to $195 million, and the operating plan is also based on a request for 133 additional full-time employees. The operating plan is divided into multiple sections, but there are a few key sections that provide some insight into what the priorities are going to be for the CPSC in the coming year. In the section on hazard identification, which is on page 12 of the operating plan, they indicate that they want to focus on the following safety issues: portable generators, Internet of Things, off-highway vehicles, rechargeable high-energy batteries, electric scooters, smoke alarms, and carbon monoxide alarms. The plan also indicates some additional priorities in this area, particularly 3D printing, safe sleep practices for infants, home fire hazard mitigation, and the evaluation of chronic hazards from chemicals. So each of these areas, we can expect to see increased activity from the CPSC in 2023. The section on compliance and field operations also provides some guidance of what we'll see with respect to compliance. Some of the areas that they indicate that they're going to focus on with respect to enforcement are safety standards for ATVs and hazardous substances packaging that is not child resistant, including the new packaging requirement for button batteries, new requirements for crib bumpers and infant sleep products, and the safety standards for products with magnets. One of the sections that I found particularly interesting is related to recall effectiveness and recall processes. For the last several years, if not forever, one of the mantras of the CPSC is increasing recall effectiveness and different tools and processes that they can implement or encourage recalling firms to implement to improve recall effectiveness. And at multiple ICPSO conferences and other conferences over the years, the CPSC has thrown out a recall effectiveness rate of 20%, saying that that's the average recall effectiveness rate. So in the operating plan, they indicate that their target for this next year is a 25% recall response rate for all consumer product recalls. And they use that 25% figure a few different ways. One of the things that really struck me is that doesn't seem like a very lofty goal. But given really the low recall response rate that we've seen over the past 5 years or multiple years, you know, it's not a lofty goal, but perhaps it's a reachable goal. Or realistic goal. So 25% target rate for recall response rate. Another statistic that I found interesting is that they said that they have a 70% target for recalls in which the firm agrees to use social media to communicate a recall. And the reason I found that particularly interesting is because every recall that I've handled, they insist that the firm use social media to communicate the recall. It's been very difficult to negotiate that point. Like many aspects of the recall, I think that issue is somewhat compliance officer, or as Matt alluded to, compliance attorney, who we're now dealing with, how aggressively they push the recalling firm to use social media. Then the last statistic that really jumped out at me with respect to recall effectiveness and recall processes was that they have a 90% target for fast track cases with corrective actions initiated within 20 days of the case opening. That I think is a very lofty goal. The fast track program oftentimes is anything but fast. I think we've all experienced that, where oftentimes the recalling firm wants to move quickly and things are bogged down with the processes and procedures at the CPSC. I had one fast track recall last year where we submitted the initial report in March and the recall was announced in September. And it wasn't because of the recalling firm. We were ready to go, but there were multiple requests of additional testing, additional documentation that really, slowed down our fast track recall. One of the other sections that really jumped out at me on the operating plan is respect to compliance and civil penalties. And the plan says that they want to expand civil penalties enforcement with 4 additional full-time employees. It also notes that there's a goal to make criminal referrals of civil monetary penalties to the U.S. Department of Justice where appropriate. I've seen different reports and analyses of the operating plan that indicate that the CPSC is going to evaluate 100% of civil penalty matters to determine if a criminal referral is appropriate. That's not how I read the operating plan. Again, the exact language is make criminal referrals of civil monetary penalty matters to the U.S. Department of Justice where appropriate. And then another thing that I really found interesting with respect to civil penalties and compliance is they indicate that they're going to incorporate improved information about firms' recall activities into the civil penalty program. I think really in the past, we have seen that civil penalties are generally levied for failure to timely report or selling recalled goods after a recall is announced. Those are really the 2 primary buckets for civil penalties. And this seems to indicate that there may be a 3rd category, which would be the recall activities, how the recall is executed, that could be folded into the civil penalty program. I encourage everyone to take a look at the document. Again, it's 66 pages, but many of the pages have charts and different information that really provide some good guidelines on how the CPSC is going to move forward. The last thing I just want to point out is with respect to rulemaking, there's a really interesting table on pages 21 and 22 that indicates kind of the status of their rulemaking activities and shows the different areas they're focusing on. And one area I found particularly interesting for ongoing or potential rulemaking is imitation firearms. And there was a recent statement by the former chairwoman Ann Brown of the CPSC indicating that she thought the CPSC should have jurisdiction over guns. So again, this mentioned in the operating plan is imitation firearms, but it does complement what Chairwoman Brown, the former Chairwoman Brown, said about expanding CPSC jurisdiction to include guns.
Okay, before I call on Matt, let me just mention the recall effectiveness. CPSC has been working on that for 30 years, and they've never quite done anything that useful to do that. And technology has changed so much over time. So it's interesting that it is in the plan. We intend to do an entire webinar on improving recall effectiveness. And I've invited the CPSC staffer who's in charge of that project. His name is Joe Williams, to participate in that panel. We'll see if he can do it, is willing to do it. But we do intend to try to find out what he's thinking about or what he intends to do, or more importantly, how we can help him figure out how we can all improve recall effectiveness. And there was one quick question in there on recall effectiveness about whether the 25%, Jennifer, you mentioned, includes both inventory at the manufacturer plus returns, or just returns. And I don't think it really says one way or another. It's just, and they certainly don't hold you to the 25% or even the 20%. I mean, I've had the recalls approved with a 4% response rate. So it's a goal, but it's not absolutely necessary. So anyway, let me turn it over to Matt. We got to move along here. And Matt, so you got the operating plans for next year. The strategic plan is for the next 3 years. So let's see if you can quickly add anything to what Jennifer has just said about these plans.
Sure. So I'll give this a very brief mention because I know we want to get into the compliance part of the program. In late December, the Commission passed another plan document called the Strategic Plan that covers 2023 through 2026. And the Strategic Plan is the vehicle by which the agency sets a high-level framework for planning, communication, reporting, and management. And it really, the agency lists its strategic objectives and initiatives in order to fulfill its mission. The document is nowhere near as granular as the operating plan that Jennifer just spoke about, but it's still worth a mention and a quick look. The strategic plan sets forth 4 strategic goals of the agency. None of this will be surprising: to prevent hazardous products from reaching consumers, to address hazardous consumer products in the marketplace and with consumers in a fast and effective manner, to communicate actionable information about consumer product safety quickly, and to efficiently and effectively support the CPSC's mission. So again, the plan, it's not program specific or product specific, but it does set out some of these goals. It does get into the rise of e-commerce, for example, the agency's relationship with voluntary standard setting bodies and voluntary standard activities. And one other example, how the agency is to identify and research chemical and chronic hazards in consumer products. And I mentioned this last point in particular because of the recent, what I'd call, kerfluffle or brouhaha that Commissioner Trumka found himself in after he gave, I want to say, Bloomberg News, some commentary on gas stoves. We could talk more about his comments later in the Q&A, but the way that the Commission gets at chronic hazards is set forth in this plan. I would just add one other comment in that I think looking down the road in the next few years, the CPSC probably sooner rather than later is going to take a hard look at its authority as to whether it can tackle PFAS, what been called forever chemicals, that have gotten much attention in the press and from local government. Certainly the EPA. PFAS has been found in many products. I think the product line that typically gets associated with PFAS are, sticking pans and that sort of product. But I do think the CPSC is going to find itself forced to look at this question. So I would expect that in the years to come. Just one little insight.
Okay, just a reminder, both these plans will be on the website, and they've got budgetary items in there that you can see, and you can take a look at that. There was a question, I just want to respond to it right now. We only have the slide for the agenda up there. We're just talking to these points. We're not, there's not a bunch of material. It's just in a webinar of this length. We can't get into, it takes more time to put a bunch of detail on slides. So we're not putting a bunch of slides up like that. So you should be seeing both the speakers and the agenda slide, and that's what you're going to see. Okay, let me turn it back over to Matt to talk about the first issue on compliance, and then we'll ask Jennifer to talk about the civil penalties part of it. Go ahead, Matt.
Sure. So compliance, I mentioned before that the compliance function at the CPSC has very quickly become much more aggressive. I have personally found that at the staff level and dealing with the compliance attorneys. I want to focus on one particular aspect of the compliance function here, and that's unilateral press releases. And that's because this is an enforcement tool that's been around, but that has really taken on much more importance and has been much more prevalent over the past year or so. So since last spring, I counted about a dozen unilateral press releases that the commission has issued. And that number may not seem very high, but consider between 2011 and 2019, the agency issued 2 of them. So what exactly is a unilateral press release, and why should you care about them? Well, typically when a company wishes to recall a product or agrees to one upon request from the CPSC, the parties work collaboratively on a joint voluntary recall. The CPSC and the firm reach an agreement on the nature of the recall, how it is to be effectuated, the remedy, and then that recall is published jointly, the CPSC and the firm, through various communications channels. However, on occasion, the CPSC and the firm will not be able to reach agreement on the need for a product recall or the recall's underlying details. And, what happens in that case is the CPSC tends to, I have found, threaten or use as leverage what is called a unilateral press release, and that is a document in which the agency will put out a press release that expresses the commission's concern about a typical product, and it will very frequently, if not always, ask the public to stop using the product because they believe it either poses a substantial product hazard or unreasonable risk of injury or death. It is just short of using the word recall. It is not that. A mandatory recall needs to go through an administrative litigation process, which is very timely and expensive and costly. So, the unilateral press release has been used as a bit of a end run around, I think, the statute, which provides for this lengthy administrative litigation process whereby an administrative law judge gets to make the call as to whether the product poses a substantial product hazard or should be recalled or not. So when the commission publishes one of these press releases, that is what we refer to as a unilateral press release, and it has, in a way, the same practical effect, if not worse, than a recall. It could serve as the death knell of a product or a company. Perhaps one of the reasons why it has been sparingly used traditionally, but it's for this reason that most companies try to avoid being on the receiving end of a unilateral press release and ultimately agree to conduct a voluntary recall. While the CPSC does provide companies with an opportunity to comment on what the CPSC plans to publish in a unilateral press release for 6B reasons or otherwise, there's not all that much a company can do short of going to court and seeking an injunction to stop the issuance or publication of the press release. But of course, if a company were to do that, the draft press release would likely be a public document, thereby defeating the purpose of going to court to stop its publication in the first place. I think, and I'll close with this thought before turning it over to Ken and Jennifer, that I think we are just going to see more and more of these. I think the commission very much likes issuing these press releases. They like the leverage that they have in using them. I think their legality, as long as the commission provides 6B notice and rights to the firm that gets named, or the product that gets named, the commission believes it has the authority to do this. Hasn't been litigated. You wouldn't find anything on a unilateral press release in the Consumer Product Safety Act, the agency's enabling statute. But I think they find it to be convenient and powerful. And again, with this new Democratic commission, I would expect more and more to be issued in the months ahead.
Jennifer, do you have any comment on what Matt was just talking about?
I just agree with everything he says. It's really, there's been a dramatic increase in the unilateral press releases. And I was just going through the recalls of last year, just kind of scrolling through the CPSC website. And it was really amazing how many there were. I mean, I remember a few years ago, they were almost non-existent, very, very rare. So I agree with everything that Matt has said. I think we're just going to continue to see more and more of them.
Okay. All right. Well, let's turn to the penalties portion of it. So Jennifer will take the lead on that one.
Yeah, so as I mentioned earlier, the penalties usually fall into two categories. One is failure to timely report product hazard, or the other one is continuing to sell products after a recall is announced. Or sometimes, like in the most recent civil penalty, you have both of those. So the most recent civil penalty was just announced earlier this month, and it was the Peloton civil penalty. And there are a few things that really stand out about it. First of all, the penalty involved the Peloton treadmill, and there had been 150 incidents of entrapment in the, or alleged entrapment in the treadmill, and there were 13 reported injuries and 1 reported death. So again, the amount, one of the things that really stands out is the amount of the civil penalty. The civil penalty was $19,065,000, and it was $16 million for failure to timely report the safety issue, and then an additional $3 million for continuing to sell products after the recall was announced. And the CPSC found that Peloton sold 38 treadmills in a period about 3 months after the announcement of the recall in May 2021. So for the sale of those 38 units, they tacked on an additional $3 million in civil penalties. Another thing that really jumps out about this civil penalty is how relatively quickly it was announced after the recall. So the Peloton recall was in May of 2021. And again, this civil penalty was announced earlier this month. So from the time the recall was announced to the time of the civil penalty, it was about 1.5 years. And that is really dramatically faster than really any civil penalty that I can think of, and certainly faster than the last few that have been announced. The CPSC really has a template that they've developed for their civil penalty settlement agreements. So you see the same terms really in most civil penalty agreements. In addition to paying the monetary fine, there are several provisions related to the compliance program that the company has to maintain. Things like they must have written policies and procedures on compliance. They have to have procedures for the prompt identification, quarantine, and disposition of recalled goods. And something that we've been seeing lately, the civil penalty settlement agreements also require the firms to submit a report sworn to under penalty of perjury detailing their compliance program. And they have to submit that annual report for a period of 5 years. So immediately before the Peloton civil penalty, there was a much smaller civil penalty involving clawfoot shower chairs. And that civil penalty was $6 million. So comparing it to Peloton, there are a number of things that distinguish it. First of all, there were no alleged deaths. There were 194 incidents and 23 injuries alleged related to this product. So the number of incidents is higher, and the number of injuries is higher than Peloton. But there certainly, was no death alleged with this product. This product, or this civil penalty, was more typical of the time frame that we usually see. The press release for the clawfoot recall was December 2018. The civil penalty was announced August 2022. So it was almost 4 years from the time of the recall to the announcement of the civil penalty. And the standard requirements that I mentioned with compliance programs, submitting an annual report, all of that stuff that we saw in the Peloton civil penalty, you saw in the clawfoot civil penalty settlement agreement. The one immediately before clawfoot is TJ Maxx. This one is different in that it was only focused on the sale of recalled products. This civil penalty was $13 million. And the CPSC found that TJ Maxx sold 1,200 units of 21 recalled products over a several year period. The press release on this issue that TJ Maxx had sold recalled products was November 2019, the civil penalty, July 2022. So this was 2.5 years between the time the press release was issued and the civil penalty. The settlement agreement had all of the provisions that were found in the Peloton civil penalty agreement, but it also had an additional requirement that it really stood out. Not only do they require enhanced compliance programs and different elements in their compliance program, but they specifically require that TJ Maxx have a senior management responsible for compliance, including a vice president of risk and compliance. So they specifically specifically required a vice president of risk and compliance for TJ Maxx. And then the last civil penalty before that was the Vornado civil penalty. That involved a space heater. There were 19 fire incidents, including 1 death. The recall was announced April 2018, civil penalty May 2022. So that was 4 years between the announcement of the recall and the civil penalty. And the terms are really those standard terms that we saw in Peloton with respect to the compliance program and submitting the annual report. Commissioner Feldman has issued some very interesting statements on each of these civil penalties. The first that I just wanted to highlight is his statement on the TJ Maxx civil penalty. And first of all, he says that he really believes that TJ Maxx should have received the maximum amount They did not receive the maximum amount, given that they have had repeated civil penalties for continuing to sell recalled goods. This was not the first civil penalty for that issue against TJ Maxx. And then he also mentioned that for a repeated violator such as TJ Maxx, he really believes that a third-party compliance monitor should be required. And this is a theme that we've seen come up. And in fact, the chair mentioned that a third-party compliance monitor, or the option of requiring a third-party compliance monitor, is on the table with respect to future civil penalties. He mentioned that at the October SPSP webinar. Another interesting statement by Commissioner Feldman is related to the Peloton statement. He noted that there's a lack of coherent civil penalty policy. And he points to the Vornado civil penalty, which was only 7.5 million. The Peloton civil penalty, on the other hand, was the maximum. And he believed that the Vornado conduct was more egregious. So he goes on in his statement on the Peloton civil penalty to talk about the need for the CPSC to develop a more coherent civil penalty policy because it's almost impossible to advise a company what a potential civil penalty will be, because they're really all over the board with respect to the timing, with respect to the amount, with respect to what the CPSC finds egregious. So I found his statement on the Peloton civil penalty very interesting. So I think in general, what we're seeing with civil penalties is, one, there's been a great dramatic increase in the amount of civil penalties. And if Peloton is any indication, we might be seeing civil penalties negotiated and announced more quickly. Again, 1.5 years is really the fastest civil penalty I've seen between the time the recall was announced and the civil penalty. So yeah, I guess with that, I will turn it back over to Matt.
Well, let me add, Jennifer, criminal referrals, Peloton or otherwise, any thoughts on whether you think that'll happen?
You know, it's difficult to say. The operating plan did mention, referrals where appropriate. It's just difficult to say because they haven't made any statements, specifically related to these civil penalties. Based on, if you're reading the tea leaves, based on Commissioner Feldman's statements, it seems like he would say that Vornado is the most likely candidate, because he said in his statement, the firm kept this product on the market for almost 9 years between 2009 and 2018 before initiating a recall. There is evidence that corporate leadership at Vornado knew about the defect as early as 2014 and may have actively concealed this information from the commission. And then he goes on to note that the one death related to that product was a 90-year-old World War II veteran. And he says if the product had been recalled earlier, when the company knew about this problem, that death would have been prevented. So, if you're looking at the commissioner's statements for a guess on criminal referral, that seemed to be among the strongest statements in the various, the strongest statement in the various statements that have been issued by the commissioners.
Yeah, and obviously, even if they make the referral, the Department of Justice would have to accept it and prosecute, and they have a complete prosecutorial discretion. So even with a referral, it doesn't guarantee that there'd be any prosecution or not. So that's somewhat dependent on philosophy of the Department of Justice and the time they have available to do things like that. So it's still going to be rare. even if they do start making more referrals. Well, we're going to take one more topic that Matt's going to take the lead on rulemaking. And I've been trying to answer some questions to individuals where they were pretty narrow questions and I knew we wouldn't get to them. So hopefully you've gotten my answers and we won't deal with them during Q&A, and we'll hopefully have a few minutes for Q&A. And because there are a couple of topics that we can get into that I've been holding for Q&A depending on how many questions we have. So Matt, you want to talk about rulemaking?
Sure, and I'll try to keep this to 2 minutes or less, so we do have time for Q&A. So clearly, much of what the agency does is rulemaking or standard setting. Congress provides the Commission with authority to enact regulation in the area of product safety, and the Commission must follow the processes that are set forth in the Administrative Procedure Act, or the APA. Rulemaking typically comes about from either a directive of Congress, but there are certainly ways for consumers, businesses, trade associations to petition the agency to start a rulemaking to address a certain product or hazard. And there are also occasions when the agency commences rulemaking on its own accord. I want to point out one nuance with CPSC rulemaking, and that's while the CPSA empowers the agency to promulgate mandatory rules, the statute also requires that the Commission give preference to voluntary standards in lieu of promulgating mandatory rules. If the Commission determines that a voluntary standard would eliminate or adequately reduce an unreasonable risk of injury, and if there is substantial compliance in the field with the voluntary standard. That was an amendment to the Consumer Product Safety Act that was introduced, I believe, in 1981 during the Reagan administration and during a period of deregulation. And that is why the CPSC is so involved with voluntary standard setting, why there are so many more voluntary standards than mandatory federal safety standards. Very quickly, I'll just rattle off a few. As Jennifer mentioned, if you go to the operating plan, there's a nice chart that sets forth various rulemakings and where the CPSC is within that process. Recently, last fall, the Commission approved a new federal mandatory safety standard for clothing storage units, what's commonly, I think, referred to as tip over rule, dealing with stability requirements, how the products are tested and labeled to emulate and reflect real world-like factors, for example, like a child climbing on a chest or dresser, to ensure that that piece of furniture does not tip over. The following month in November, the agency enacted a safety standard for operating cords on custom window coverings. Standard window coverings, which make up about 80% of the market, are covered elsewhere, I believe by voluntary standard. Cords on custom window coverings, so custom window coverings make up about 20% of the market. A trade association has sued in the DC Circuit over that rule, and that rule has been stayed, as I want to say, as of last week, pending the result of that litigation. Just last week, the CPSC enacted a rule requiring gas cans and certain fuel containers to have flame mitigation devices. And also, one final rule that I'll mention, what's gotten a lot of press, Risa's Law, named after a young girl who tragically passed away after ingesting a button cell battery. Congress passed a law which gives the CPSC 1 year. So it was enacted in August, so 1 year will be August of 2023, to enact a mandatory safety standard for button or a button cell or coin batteries and products including them. One last mention, just because I have to, gas stoves, read the statements that Chairman Alex Hohn-Sarek made in response again to that kerfluffle from a week or two ago. The CPSC is not looking to ban gas stoves. and has no proceeding currently to do so. It is researching gas emissions and exploring ways to address potential health risks from gas stoves, but by way of rule or otherwise, that we should not expect a rule banning gas stoves anytime soon. He put out a very helpful clarifying statement given all of the chatter that's been on social media and the press and even from some congressional members.
Yeah, let me just say, if I've had experience with submitting petitions for rulemaking to the CPSC on behalf of a manufacturer, and those really get stuck in the general counsel's office. There's one attorney at general counsel in general counsel's office who reviews the petitions and determines whether to even send them to the commissioners. So to get in front of a commissioner is really hard to do. And you can submit your petition, you can go for 6-9 months, you never hear a thing. And you find out what's going on, well, we haven't read it yet or whatever. So it's a very cumbersome process if you are an outsider to the CPSC to try to get something in front of them. I kind of wonder whether you can just sort of contact their staff and raise an issue that they ought to be interested in. Of course, if a commissioner is interested in something, but that could be a potential rulemaking, obviously gas stoves fell in that category, you might be able to get them to either accept the petition, want to receive it, or whatever. So there might be some ways to get in front of the commissioners and get their interest, which is in my experience, has been very hard to do. Okay, we sort of got to this, and I want to take questions now. I've answered some of the narrow questions. Just a second here. Well, I have something from Mark Shum, so I better read it, or he's going to yell at me or something. He wanted me to point out, I guess, that the CPSC morning at ICFSO on February 23rd will feature updates from CPSC staff on rulemakings, proposed rules, enforcement, and information and education campaigns. And you can look at the agenda on the ICFSO website. So we encourage you all. We always like to hear from the staff. It's nice to hear from them in person. So, take a look at that. But let me do a question here. Let's, I want to change this slide. Thank you, Mark, for that comment, by the way. There's a kind of a tricky little decision that companies have to make when they file 15B reports. And that is, do I file fast track? Do I file non-fast track? And do I file to the regulatory group? And let's say I have a regulatory problem that's also could be a substantial product hazard, although I don't want to admit it's a substantial product hazard. So which group do I file with? And then secondly, as many of you know already, if you file under fast track, you have to use the online portal for the CPSC, which in my experience is very difficult to use. Maybe I'm not computer illiterate, but it's just not very user friendly. And I prefer the non-fast track filings. Jennifer, you've talked to the fast track folks about this. Can you briefly give us an update on what you found?
Sure. So the new online system was implemented last year, and there have been a number of kinks and a number of issues that still need to be worked out with the system. First of all, as a lawyer, I was not able to register and submit a report on behalf of my client. So my client had to register and then add me as an authorized user, and then I was able to submit the report through the online system. So that was just one kind of small hurdle, as opposed to not using the online system where I'm able to just communicate with the CPSC directly. The second challenge to the online system is there's no template that shows you all of the fields that you're going to have to fill out. And you can only advance to the next screen after you've completed a screen. So the first time I used the online system was really challenging. I had to, fill out the first page. Then I clicked onto the second page. I had to see what was required. I had to reach out to my client and say, okay, they want this additional information. Then I'd fill that in, go to the third page. Then I'd have to go back to the client and say, okay, this is what the third page. I brought up this issue to the fast track team and asked them to provide a template for the online reporting system. And they said, well, it's just the same as the Rule 15B, what you've done before. But it's really not. It doesn't match up one for one. So the online system, it's a different format. It asks for some of the same information, but some of the information is different. And then at the end, after you've gone through the various pages and filled out the online system, you have the option to upload documents. So that could be testing reports, the photographs of the product, so on and so forth. Well, 2 times when I've used this online system, I've uploaded about 15 documents, but then the CPSC compliance officer can't see them. And I've had to just send it to them by email. So there's just a lot of procedural, technical issues that I think still need to be worked out with the online system before it's the streamlined process that the CPSC envisions that they want it to be.
Yeah, let me say, on the submission of monthly progress reports, you also have to do that online. And I do that, and I've registered myself to do it. But their form is screwed up. I get calls from the CPSC attorney that there's something that I didn't add in there, and he couldn't even see the form. I said, well, no, it doesn't say that. That's the way I interpret it. So it's ridiculous that we have to argue over interpretation of a document that is important, but it's been unclear for years. But now we have to do it online and submit the form, all the time online. The one last thing here before we go, get 3 minutes here approximately. Do either of you want to comment on 6B and what you think is going to happen to changes in the 6B process? Matt, you got any thoughts on it?
Yeah, I think the agency is going to try to push the limit when it comes to 6B. I think statutorily, and I'll just quickly speak to this, the Democrats, when they controlled the White House and both chambers of Congress, that was their best shot at repealing or amending 6B. There was talk, there were bills introduced, that didn't happen. And now with a Republican-controlled House, at least statutorily, that repeal or amendment, I think, is going nowhere fast.
Okay, let's see. We got one more quick question. Do either of you have any idea about when the empty commissioner position would be filled?
It's a great question. I don't think it's going to be filled anytime soon. I haven't heard much chatter about it, from the usual suspects. The reality is, even if a Republican commissioner were to be nominated and confirmed, the Democrats still have a 3-2 majority, so it's not changing the balance of power or dynamic at the commission. The Senate is controlled right now by the Democrats. So, typically commissioners are paired, one from each party. With respect to nominations and confirmations, I don't think this is going to be high on anyone's priority list. So I think it's a great question, Don. I haven't heard anything that would lead me to believe otherwise.
Okay, and I'll answer the last question.
Sorry,
Oh,
Ken,
did you have something, Jennifer? I'm sorry.
I just wanted to mention, if anyone wants the summary that I presented on the operating plan, you can just email me at that address and I'd be happy to send it to you. It's just a bullet point, list of what I mentioned during my talk.
Yeah, and that's, since that slide is up there, yes, if you have all of our email addresses If you have additional questions, we will post the material at after the webinar is over. And you know, we even have the ability, if we get a number of questions that deserve you know, more comprehensive answers, we can prepare written answers and post them on the website or put them in the SPSP newsletter. So we have ways to get you the information that you need. Don't be shy about asking questions. Many times we can answer them, you know, very, very quickly, and it's not a big deal. One last thing here, and then we'll end. Has there been any consideration to help improve consumer response to recalls by having manufacturers offer some kind of incentive to encourage consumers to complete and return product registration cards? Well, yeah, they've talked about that over the years. Certainly the big impediment on returning registration cards is that the manufacturers put all kinds of marketing information in there. So you look at this card and it was like 4 pages long, and you didn't want to screw around doing it. But there are companies that have offered some kind of incentive, an additional warranty, for example. So certainly companies are thinking about it. It could be part of what the CPSC is thinking about in their recall effectiveness project to encourage maybe manufacturers to do it. But it's you need the registration cards. And you know, I've got clients that get the registration cards and then they're bothered to input it in the computer. So when we have to do a recall, they have to kind of start from scratch to do it. So getting online registrations is much faster, of course, and should be the state of the art, and not requiring a bunch of marketing questions. Give them something if you can, a little bit of something to do that. And you know, that's so. Yes, there are people trying to figure out how to do this. It depends on the product and depends on you know, what you want to offer them, whether it's valuable or not, and whether you're willing to do it. But the other part on recall effectiveness that we'll talk about later is how do we communicate safety without overstating the problem to the consumer? You don't want to scare the heck out of them, you know, with your notice, but you do want them to respond to the recall. So how do we do that? It's a very tricky safety communication message that you have to get out. So in any event, let's do this. I want to thank Jennifer and Matt. That was great today. I appreciate it. Lots to talk about. You guys did a great job. Hopefully we will answer most of the questions that came in here. I was looking at them throughout the hour. And SPSP thanks you for participating today, and we hope you participate in the future at a webinar that would be of interest to you. And again, those at your company who have not been on the live presentation, this will be archived, as all of our webinars are archived, and feel free to have them, take a look at them, and share the information with them. Okay, with that, I think we'll stop. Thank you all very much.
Thanks, everybody.
Hey, Loudon, you're there?
I am. I'm ending
Okay.
the meeting now.